today, which is my final day of cross-examination. And you all realize that the Attorney General and all his team, they were comprehensively demolished by the evidence I adduced in court and the explanations I gave to the court. You realize that they were confused and they didn't know which next question to even ask. And they were having difficulty even adding mathematical figures together. It was all demonstrated as a clear sign of ineptitude and incompetence on the part of the Attorney General in presenting this case to the court. And the evidence they brought. In fact, the evidence they brought were evidence that were very, very irrelevant. I say so because they brought evidence of years prior to 2016. And Honorable Alex Segbefia, the last minister of the NDC government, had dealt with all the implementation hiccups of this ambulance problem issue. In fact, he has sent a team to Dubai to go and negotiate all the implementation problems that were occasioned right from 2012 to 2016 before he left office. In fact, the team that led the delegation for the dispute resolution, which is grounded in the contract, was led by Honorable Professor Ahmed Zakaria, the CEO of the National Ambulance Service. And they came out with an addendum. An addendum is founded on clause 23 of the contract, which is amendment. And no amendment or anything outside the contract can be valid unless it is signed by both parties. And this is what the both parties agree to. So when they send their team to Dubai to go and negotiate on the implementation difficulties, which is normal in international contracts, especially in manufacturing of such nature, when they are custom made. Because ambulances are not manufactured on the shelf for you to go and buy. Like the way you go and buy a Land Cruiser, you go and buy, they're already manufactured. No. Ambulances are made to specification of the purchaser. So they have to buy all the accessories from around the globe, bring them together, and with delivery schedule, manufacturing schedule, to put them together. So when they do it and in the contract says that you have to come for pre-shipment inspection to come and check and be sure that what you signed for is what has been produced. And you decide that, oh, I don't care, I will not go and inspect of an international contract. And you think that by refusing to go and inspect, the contract is ended. You must be living in a wonderland. The manufacturer will proceed to ship the products to you. Because in the contract, there's also a clause. If one particular area is breached, it does not prevent the other areas from being implemented. So if you have waived your right to inspect, it does not stop the supplier from fulfilling other obligations in the contract. And also, the supplier used their own money, loans they took from banks, to manufacture. And you only secured the transaction with an LC, with condition precedent for the supplier to meet before he can be paid. And the condition precedent is talking about bill of lading. How do you get a bill of lading? It's only when you have shipped the goods that you get a bill of lading to send to the purchaser's bank to meet the preconditions in the LC. So if you refuse to come and inspect, which is your right to waive and bear the consequences, and they also have the right to ship and get the money they've invested. So they ship the ambulance to you. You refuse to clear the ambulance from the port, the first 10. The ambulances were vandalized by thieves at the port. They stole almost all the accessories in the first 10. Supplier was informed. The subsequent 10 to make it 30, you government agreed with the supplier that, look, because of what had happened, all subsequent shipment put the accessories in a separate container and bring them so that they are not stolen or the sea waves because they are disposable accessories in their cabins. They don't hit left and right and damage. This is common sense. So they put them in a separate container. They ship it. And there are letters and agreements to that from the Ministry of Health, signed by the former Chief Director, Sylvester Animana. So the government knew about accessories. They arrived at the port way back in November 2016. The following month, there's election. The previous government loses the election. They hand over the accessories, the bill of lading, everything to you, incoming government. Even Honorable Esefifia had written to the Minister of Finance that, look, government has taken delivery of the accessories. And all the implementation hiccups that were occasioned by his predecessor, Serwaa, and also his colleague minister, Jakpa, in refusing to establish the LC on time, all had been resolved. So proceed and establish the LC so that the rest of the 170 ambulances can come to Ghana for the Ghanaians to use. This letter was written in December. I heard the Deputy Attorney General espousing ignorance here, and I'm shocked. And I'm saying ignorance because it's premised on law, and the man is ignorant on that. How can you tell the whole world that that letter Lesofia wrote was written in December, and it was post-election? Election is 7th December. And MPP won. Yes, they won. But they don't have executive power until they are sworn in by the Chief Justice on the 7th of January. So from December that the letter was written until 7th January, the power of executive and to sign and dismiss and appoint was still with President John Dramani Mahama, not Akufo-Addo. So you can't say that that letter Lesofia signed in December is of no effect because it was post-election. That is pathetic ignorance of a Deputy Attorney General speaking this way.
Mr. Jakpa, you seem very confident that government didn't have a case to begin with. If so, then why do you think the Attorney General came to court?
Attorney General came to court purely on political convenience and mischief to imprison Honorable Atuforsen. And this stemmed from the e-levy. It stemmed from the e-levy because Honorable Atuforsen was a ranking member for NDC in Parliament. And he was giving them headaches. He was frustrating and being meticulous on the figures that Ken Ofori-Atta was bringing to Parliament. So on the insistence of Ken Ofori-Atta, they decided to charge Atuforsen in order to intimidate him, to soften in Parliament, so that he doesn't peruse and be too critical on the things that Ken Ofori-Atta brings to the Finance Committee. So they decided to charge him and hang that on him to intimidate him, to cow him down. But in doing so, they realized that it will become too obvious that this is a witch hunting. So, well, let's add the agent of the supplier to it, to max it and deceive Ghanaians and let it look as if it is not a witch hunting. It is a crime that they've all committed. Is it not surprising to you that you have a contract with a principal outside the country? Your LC is 100% to the principal, who is the recipient. You paid it direct to the principal. You have not charged the principal. You have not instituted any civil case against the principal on the contract, both criminal and civil. You've done nothing. Then you come and hold the appendage of the principal, which is the agent, and drag him to court and say you have committed financial loss. Yet, you are at ADR to negotiate with the principal on the same contract that you are charging his agent. And when the principal decided to take you at government to the civil court, commercial division, and sued you for judgment debt, you, the same Attorney General, Godfrey Dame, you went to the court and filed motion in the court that the court should refer the case to ADR because the contract that you are charging his agent on states that any dispute or misunderstanding arising from the contract must be settled at ADR. So he, the Attorney General, he knows about this clause. So he conveniently goes to the civil court and go to argue there. Then the civil court decides, okay, that is true. So they ordered both of us to go to ADR and go and solve the problem. You got this judgment. the case at ADR. He doesn't want to go to ADR. Then you are at criminal court, the same human being. You are at criminal court trying to jail the principal that you are at ADR of. His agent that you don't have a contract with. Because from his own term, as he told me in my cousin's house, I'm a collateral damage. And in a political trial, there must be a collateral damage. So I should understand that.
Now, if you look at
what kind of human being is this?
The cross-examination of the Attorney General, in fact, I would say like 4.5 days, because the very first day when they started, they asked you only 2 questions and all that. How would you rate that particular cross-examination from the Attorney General and all this that you are seeing?
Which of the
The
cross-examination?
cross-examination by the prosecution of you.
Today or all?
All the 4 days that they had with you.
Oh, their cross-examination is, I don't even know how to describe it. It's just below the bar. It's below the bar. They were legally incompetent. They laughed. Below the bar. What I'm trying to tell that they were legally incompetent, very inept at arguing their case. You were in court. You saw that he was bringing documents and he was even confused. He didn't even understand that there is an LC account in the bank. And the LC is established from the account of the bank, from an account of the LC. So there's difference between 15 and over million and 3.9 billion, which was meant for the first 50 tranche, which came from the ministry. And the man was telling the court that debit and credit balance, which was open and closed, and the charges in the bank, that was the LC. That is completely, it's just pathetic. And you are there and I had to educate them, my brother. That is the account of the LC. But the LC that the Minister of Finance signed was 3.95 million euros. Understand my point? That is 1/4 of the money that was in the open balance. That is over 15 million euros. So the real LC was a 3.95 million euros, which at the back of the page, you have the condition precedent. But on the opening balance, there's no condition precedent because it was just the Ghana International Bank opening the LC account for all the 15 million euros for the 200. And out of it, they removed the 50 cost of the ambulances for the next LC of 3.9. And this Attorney General, he cannot decipher. He can't even interpret common LC documents. And I on the audio that I released, you realize I educated on the LC. And I was expecting that today he would have come well informed, even get consultants to school him proper. But he still came there and came and repeated the same ignorance. And I have to point it out to him again.
From where you sit in the witness box, if you had to rate the Attorney General's performance of your cross-examination, how would you rate it?
In fact, well, if it is a scale, if you give me a scale, maybe there's a scale from
a scale of 1 to 10.
1 to 10. I'll give the Attorney General 3.
3?
Yeah, 3 over
3
10.
out of 10.
3 out of 10. That will be 3. No. I'll give him 3 out of 10.
But in all this, you trying to indicate that the government rather who is trying to cause financial, this current administration is the one trying to cause financial loss to the state, because even as we speak now, those accessories, you don't know their whereabouts.
There's no argument. It is very clear that from 2017, January, there was no any issue of ambulance in this country. All the issue that started in 2012, occasioned by Honorable Sherry Aite, the late, may his soul rest in peace, and the mischievous Jakpa at the Minister of Finance, had been resolved by Honorable Alexander Sebefia in 2016. He's resolved the problem, wrote to that effect, and handed over to Honorable Ajimamenu. Now, MPP took over. I personally went to Ajimamenu and reminded him that, look, there's no issue about this ambulance. It had been resolved. This is the letter of the addendum, the letter signed by your predecessor, just the following month, in December, and you are just taking over. No, I think he took over in January 7th, and he was sworn in somewhere around March or April thereabout, when he was vetted and approved. So I went to his office. I showed him the 2 letters. The addendum, which was negotiated in Dubai, and the letter written by Let's say if you are solving all the problems. You know what he told me? He said, Jakpa, I've seen this letter, but my hands are tied behind me. Now this ambulance case, the party headquarters has taken over. That they are going to also import their own ambulances so their businessmen can make money. NDC people, they caused this mess when they were in power. They should come and clean it up. We are not going to clean that for them. So, based upon that, they refused to give the accessories, which was by then at the port, because they arrived around November 2016. So there was not enough time for Alessabefia to clear them before handing over. That's what they gave to Ajimamenu. And they billed in everything of them. So they should just go, clear the accessories, inform the principal Big C, technical people will fly down. They are not that you are now coming to manufacture the ambulance. No. The accessory disposable, that you are just coming to put them in their compartment, put screws and tighten them in some area. Finish. That is all. Now, they refuse to disclose to Ghanaians that there was a 20-footer container full of accessories. And not only accessories for the ambulance, part of the ambulance. There was accessory even for the vehicle Mercedes van ambulance itself, which is not part of the contract. And those spare parts were for Jakpa business in repairing the ambulances should there be any problems on the ambulance itself, the vehicle itself. All these accessories are at the port. And my checks, and with the shipping company, they have emptied the accessories from the container. And as I speak to you, the container is in China, roaming around. I've given the evidence out, and you see them on the screen, onto your TV screens. The containers are roaming, working. They've emptied the accessories. They've refused to inform the supplier to come and fix them. They refuse to tell Ghanaians that this is what we've done, because they want to make sure that Ghanaians continue to believe that there were no accessories, they are empty ambulance, so they can jail Atufosu. This is just a despicable Attorney General, despicable government, appointed Attorney General appointed by a despicable president who has no character. And they will go at any length to get innocent people jailed just because they have power.
That's maybe
to them by Ghanaians.
That's maybe below the belt, Mr.
It's
Jakpa.
not below the belt. When
but
you
finally,
want to take somebody, an innocent person's liberty away from him, there's nothing like below the belt.
Finally, before you go,
because you know why I'm saying it can't be below the belt, because nations have disappeared on this earth because they couldn't defend their liberty. Majority of the conflict and wars in this world is because of liberty. Even the independence of Ghana was fought and people died because we were fighting for our liberty. So liberty is at the core of human existence. So when you attack an innocent person's liberty and you want to take it away from him and jail him unjustly, there's nothing that is below the belt. Okay. All cards are on the table.
Okay, thank you, Mr. Jakpa.
So that's Richard Jakpa. He is the third accused in the ongoing ambulance procurement trial. We are being asked to leave the courthouse right now because it's closed and they have to close the main gate. But in court, you kept making reference to the judge and say that the court is not being fair to you. The court kept heckling, the Attorney General kept heckling you and all of that. Are you sure the judge wasn't fair to you, because she gave you time to explain some of your point?
My brother, right from the beginning of this trial to today, I've not been treated fairly at all by the judge. And I'm saying that because I have written a petition to the Chief Justice on this. So I'm not speaking out of a vacuum. And it's recorded, it's documented. And when I wrote a petition to the Chief Justice and I enumerated all the instances of biasness, abuse of my human rights, denying me legal representation, and all the instances, and even the right to even visit the washroom, and the judge at times engaging me as an accused in court.
When you are a witness?
When I'm a witness, engaging me, instead of the prosecutor engaging me, the judge is engaging me at times. For even at times, my lawyer had to come and say, you are engaging the witness. With all this, and the petition I wrote, it's clear that in the mind of the judge, I'm already a convicted person. And I'm just going through the motion. And I stated it in my petition. So it's not something I'm concocting from anywhere. And when I wrote the petition, I didn't write it as a secret document. I copied her. She got her copy. And the Chief Justice also got it. So she knows what I'm saying is a fact. And I even stated it in the court before her. And I've no means worse. Because the scale of justice has been tilted against me. And I had to fight for my liberty, fighting the executive arm of government, and fighting the judiciary too on top.
So based on what has happened in court, your days are showing in the witness box and all of that. Quick and direct to the question, do you see yourself being convicted, or you are going to walk a free man? Straight to the point.
Well, I cannot say I should be set free or convicted. That is solely in the bosom of Justice Efia Asare-Botwe. She has to decide. She has to decide on that. That is all. As for me, I can't just stand here and say that, oh, discharge me, jail me. No. But what I can confidently say is that she has not been fair to me in court right from the beginning. She's been very hostile, trampled on my rights, treated me like a convict. And that is not fair. I should have been presumed innocent until proven guilty, and not guilty and now I have to fight for my innocence. Not the other way around. But as to whether she will go ahead and convict me or discharge me, that is in her bosom. She will have to decide finally. I cannot preempt that. That will be prejudicial, and I can't do that.
Thank you very much.